Hello, everyone. Welcome to another episode of the Lifetime Legacy Lawyer podcast. I am your co-host, Thomas Vick, joined by my other co-host, Seth Wilson. Seth, how are you today?
Thomas, I'm doing great. How about yourself?
Pretty good. Doing well. It's been another good week down here in Greenwood, Indiana. How about you?
Yeah, and I think honestly, the switch over, we're recording this around the switch over to daylight savings time here in central Indiana, and it just kind of threw everything off. I was waking up an hour earlier going, why am I not sleeping too? And try to figure all that out. So I think getting a couple days in a row of rhythm has been helpful for that now that we're kind of on that new cycle and driving home in the dark now.
For sure, I can definitely relate to that. But another weekly blog digest went out this week, and the topic in that blog was 3 big reasons to have an estate plan. And the first reason that was listed is securing management of healthcare and finances if you're incapacitated. Um, you know, the unfortunate situation is if you don't have that, then you're going to have to get court involved. And that's probably the biggest caution that people have. They don't want the court to become involved in their family if they can help it. We're attorneys, and so we're familiar with that process, and we understand that it takes a long time and it's a process, but it's not too intimidating for attorneys. But for a family that just wants to keep things simple, a guardianship or some kind of protective order, that's going to be a lot of stress, a lot of headaches for a family if a loved one does not have an estate plan in place.
I think another point on that, Thomas, that you don't always appreciate when you're thinking about estate planning. You're kind of thinking about end of life, transition of assets, and not always thinking about, well, what happens if something does happen to me during life and I do become incapacitated? And so that's one of those educational pieces we're able to help clients to think, well, have you also thought about what would happen if you need someone to step into your shoes to make decisions and do financial management? And it could be as simple as, you have a surgery with an extended recovery time to where you're not really going to be able to get out and about and go to the bank like you used to. Those kind of things. And so that's that hand in glove fit of the estate plan coupled with your incapacity document, your healthcare power of attorney, and your health or your general durable power of attorney, advanced directives, and those kind of things that can really, I think, are really essential components to having a well thought out and prepared plan.
Absolutely. And the second reason was just to make sure that your wishes are fulfilled. So, if you don't have an estate plan, the state of Indiana has one for you. Congratulations. But that may not be what you actually want. And, if just have kids, it will go to your kids. If you're married, then some portion will go to the spouse. And then if you have kids, then some to the kids. It just kind of is a scenario by scenario situation there. But the state of Indiana will decide, who gets what, and you may not want that. And a lot of times that's when, if there is a surviving spouse, a portion goes to the surviving spouse and then the rest goes to the kids. And that surviving spouse may have been needing that inheritance to be able to survive. And it's really, really important. And if the family's not getting along, it's not going to be a good situation. So making sure that your wishes are carried out is done by doing your estate plan.
Yeah. And that's such an important part of the puzzle because there are so many issues that can come up that you're not even aware of, from joint account ownership, beneficiary designations, and intersection with how your plan works, what you may have experienced in the past. Well, somebody else passed away and I just got everything and that worked fine. And so just really understanding what your asset base is and how to handle that is really important. And I think it kind of goes hand in hand because you can also create additional issues that you may not have thought of, especially as you get into maybe a long-term care scenario, where ownership of assets is really important for determining eligibility for benefits. And so there's that intersection of if we're moving things around inappropriately, that can help or hurt our chances for becoming Medicaid eligible as soon as we might have been able to. And so there's just a host of dynamics and variables that come into play as part of that, really fulfilling what you want to have happen.
Exactly. And, when we're specifically talking about Medicaid and the Medicaid application, you can really mess up big time if you don't know the rules. And, people don't know the Medicaid rules. That's why elder law attorneys study them very, very carefully. And it takes years for attorneys to get a feel for what the Medicaid rules are and what you can and cannot do, speaking from experience. And so it's one of the biggest assets that people have is the principal residence. How can I protect the house? And there are certain situations where you really can protect the house, and it's a very simple measure that needs to be taken in order to do so. And, there's just some exceptions to what transfers are able to, or what transfers can be made. And the first one that I can think of is if an adult child has lived in the house for 2 years in order to take care of mom or dad, and that has allowed mom or dad to continue to live in the house and not need to go into a nursing home or get on Medicaid waiver, that transfer is going to be exempt. So you can transfer the house to an adult child who has lived in the home for 2 years to take care of mom or dad. That's an exempt transfer. And I think it's a fantastic one because it's pretty common for an adult child to move into the house with the kid or with the parent, so and to take care of the parent. And that adult child may have, had to sell their house or, had to have limited income, maybe no income, in taking care of the parents. And so I think it's a fair rule and one that people can really take advantage of.
Yeah, and I see, I'm sure you do in your practice as well, that's a fairly common scenario because potentially the adult child had some sort of need themselves or may have been on benefits themselves. And so the two living together has been mutually beneficial for both. And it's kept the elderly folks from that facility as long as possible and reduce the cost to make sure that they're there, and hopefully kept mom or dad in the family home as long as possible as well. That's a great case study for everyone if that can happen. So it's just really important to understand each level of planning. And you mentioned how long it takes to get familiar with the rules and how much variation there is among those rules on that side of the coin. And it's so true. I mean, if you go out and just do an internet search or you talk to someone, you're going to get a lot of different information. And so really sitting down with someone who knows, has studied, and does this over and over and over again in their practice is really beneficial and can save you a lot of headache and unnecessary stress while you're trying to figure out the answers to these questions.
And one of the biggest ones is if a child is disabled, then a transfer to a disabled child is an exempt transfer. So there'll be no penalty and that transfer can be made, and it's really, really helpful. So that's just one or two of the rules that people can take advantage of in protecting the house. There are certain situations where that's just not going to be available to you. There may not be a disabled child, or at least there may not be a child that comes in and takes care of the parent in the home. It just may not be a workable solution. And those are really planning techniques at the time of a Medicaid application. Kind of looking forward, a Medicaid asset protection trust might be the way to go in order to get the house protected, regardless of whether those exceptions to the rule apply to you.
Well, and that's kind of a nice segue to the third point in the blog post is what do you do to avoid probate? In trust-based planning can help accomplish that outcome. And those Medicaid asset protection trusts, I think, are really powerful tools for individuals who are concerned about that long-term care piece of the puzzle and becoming Medicaid eligible. So I think we talked in a recent episode about when do you do this kind of planning? And the answer is always now. Reach out and just figure out what the options are. And you may not need to take an action at this point, but you do need to know when that action may need to be taken. And so the lawyer can help you walk through that analysis and create a plan that best accommodates all of the variables that are coming down that path. So that we mentioned the Medicaid Asset Protection Trust, that's a irrevocable trust. And so that's a little different than a revocable living trust that you can put your assets into and avoid probate if you've moved all the assets appropriately. So always a good consideration there, not necessary for anyone or everyone. And the fit is really what meets your expectations and your desired outcome as a client. It gives you that peace of mind that your plan is going to be accomplished at the appropriate time. And you've considered all the necessary variables to best protect your legacy.
Absolutely. Absolutely. We kind of started out this discussion about avoiding court involvement, and a trust is a great way of doing that because, if there are there's a certain level of assets in a probate estate, you've got to go to court, at least to some extent, but a trust can avoid probate entirely if it is properly funded. And so that's a great tool that we have to be able to use for clients.
Yeah, and again, it's really that fact-sensitive discussion with the client, with all the variations that could happen, and try to figure out what vehicle, if you will, best fits how to transfer their assets at the appropriate time. And there's so many great tools with that. That's why that conversation, from my perspective, is always so interesting, just to hear everyone's story, where they came from, how they got from here to there, and what they want to do with their hard work over a lifetime, and make sure that that's transitioned appropriately among their beneficiaries, and really, like we say here, that lifetime legacy that they've created, we want to help make sure that that transitions appropriately. And so just so much fun for us to work with clients in that scenario. And then additionally, with your practice, being able to help folks really address a very, very heavy concern of how am I going to provide care for a loved one who may need it long term, and how we're going to pay for all of that, and what's that going to look like, and really coming up with a clear path moving forward to help accomplish that.
Absolutely. It's one of my great pleasures to be able to kind of walk through a client scenario and think about, well, you could do this, you can't do that. This is how you can protect this asset. This is what we need to do. It's really kind of fun to put the puzzle together for these Medicaid cases, and I really enjoy talking to the clients and figuring those things out on that piece. And I know that you do as well.
Yeah, it's such a joy for us, and it's not for everybody, right? Like I'm not a great mechanic, so I'm going to likely rely on the mechanic's expertise to help fix a vehicle issue that I have going on. But I really want to be that trusted resource for an estate plan question. And I may not be the right elder law person, because that's really where, Thomas, you come in. And so we really try to just bring that value to our clients and take care of the entire consideration as best we can. And we're fortunate in Indiana. I think there are great lawyers all throughout the state. And that's a wonderful thing, so that ultimately clients are being well taken care of through their estate planning process. And so a lot of fun to develop and work in this practice area. We get to meet so many great people through that. It's just a lot of fun there.
Absolutely. Well, Seth, how can everybody get in touch with you?
We are located here in the heart of Hamilton County in Noblesville, Indiana. That's our web address, noblesvilleattorney.com. That's the best way to find us. How about you?
I'm Thomas Vick. My firm name is Vick Law PC, and the best way to reach us is by going to vicklaw.org. Well, appreciate it as always, Seth. We'll talk to you next time.
See ya.